Hello everyone. So today we are going to discuss about the CMA Foundation May 2026 Business Law question paper. So they asked this paper in May 2026, which we are going to discuss here. So as the name suggests, May 2026 question paper discussion. See, they asked the first question for 7 marks. First question, A part, 7 marks. Let us read out. Rakesh, intending to sell his used car, approached his friend to suggest the name of reliable used car broker who can help him to sell his car. So Mr. Rakesh, he want to sell the car. Remember this name, he is the seller. His friend recommended the name of Vikas. Who is Vikas? A renowned reliable broker. So who is the broker here? Vikas. Vikas is not the buyer, he is just the broker. Vikas inspected the vehicle and there on spot Rakesh informed Vikas that he has decided to sell the car for 12 lakhs. It means Rakesh, he said to the Vikas that seller, he said to the broker that he want to sell his car for how much? 12 lakhs. This amount is important. He want to sell this car for 12 lakhs. He also informed Vikas, broker, that anyone who will be interested must give a token amount. Token amount means advance amount of 5 lakh rupees. So seller is saying that whoever want to buy my car, they have to give a advance of how much? 5 lakhs at the time of deal, and to pay the balance amount of 7 lakh rupees at the time of delivery. So 5 lakh rupees in advance, 7 lakh rupees at the time of delivery. So broker bought one customer called Ravi. So who is going to buy the car? Ravi. Seller is Rakesh. Broker is Vikas. And who is going to buy this car? Broker Ravi. For inspection of the vehicle, who inspected the same along with the mechanic which is brought by him. So Ravi, he came to the car along with one mechanic. He has examined the car. He was satisfied with the condition of the car. When Ravi informed Vikas about his interest, he came to know about the price of the car offered by Rakesh. So Ravi, after inspection, he went to the broker, said that I want to buy this car. What is the price of this car? So broker said that price of this car is 12 lakh rupees, which was informed by whom? Seller. Ravi told Vikas that he was prepared to purchase the car only for total concession of 10 lakh rupees. So broker said that seller want to sell this car for 12 lakh rupees, but buyer saying that no, I'll pay only 10 lakh rupees. And immediately buyer, he transferred an amount of 5 lakh rupees to the Vikas bank account. It means that immediately the buyer, he has transferred 5 lakh rupees advance amount to whose account? Seller's account. Who is the seller here? Vikas. Through the NEFT as advance, which was immediately transferred by Vikas to Rakesh. So of course the amount is already transferred from buyer to seller. After a week, when the parties met to conclude the sale, means after 1 year, finally they came together to conclude the sale. Ravi issued another check of 5 lakh rupees only, means buyer is paying only next 5 lakh rupees, because already he has paid 5 lakh rupees. Now he is paying the remaining amount of how much here? 5 lakh rupees as the final payment, which Rakesh rejected, because Rakesh was saying that the total price of the car is 12 lakh rupees. So you have paid only 5 lakh rupees, you have to pay the remaining amount of how much here? 7 lakh rupees. But Ravi was paying only 5 lakh rupees. Vikas tried to convince Rakesh that the condition of the car is such that it would not fetch more than 10 lakh rupees. So broker is saying to the seller, bhai, buy this car. No one is going to pay more than 10 lakh rupees. This car is having condition of 10 lakh rupees only. But Mr. Rakesh, seller, he did not agree with the broker. Said, go to hell, idiot. I want to sell only for 12 lakh rupees. So analyzing the applicable provision of Indian Contract Act 1872, answer the following questions as per the information given. So they are asking you to answer these questions here. First one, where there is legally valid and enforceable contract in this case, means whether there is legally valid and enforceable contract in this case or not, means sir, whether there is a valid contract or not. First part they are asking here. Okay. Next, briefly discuss the remedies available to the Rakesh in this situation. Who is the Rakesh here? Seller. So they are asking here, what is the option available to the Rakesh here? Whether he is bound to sell this car or he can reject this car here. Got it? Because he said 12 lakh rupees, but buyer is ready to pay how much? Only 10 lakh rupees, and he has already paid 5 lakh rupees. So can Rakesh, seller, can he cancel this contract or not? What if Vikas, broker, never actually though unintentionally told Ravi about the price, however received 5 lakh rupees? It means sir, Vikas did not said anything to the Ravi about the 12 lakh rupees. Got it? But however Ravi have transferred how much? 5 lakh rupees. Means broker did not said about the price of the car, still Ravi have transferred advance amount of how much here? 5 lakh rupees. So what will happen here? So they are asking here. So see, this is a case study, and as I said you, whenever they're asking any case study form here, you have to present the answer in a 3 form. And one more thing, all these are just the suggested answer here. So in our opinion, this could be the best answer that we are giving. Okay, so see, provision of the law. According to the Indian Contract Act 1872, a valid contract requires lawful offer, lawful acceptance, lawful consideration and free consent of the parties. The parties must agree upon the same thing in the same sense, means they must have consensus addendum. Next, if there is misunderstanding regarding essential terms such as price, then no valid contract arises. It means that if the parties are having any kind of misunderstanding, it means they're not agreeing upon the same thing and in the same sense, they don't have consensus addendum, they don't have a consent, then no any valid contract will come into existence. An agreed party may claim remedies against the person responsible for the loss. Next, if any person have suffered any loss, they can claim the loss from the other party. So see, Rakesh, who intended to sell his car for 12 lakh rupees, informed the same to broker. However, Vikas, broker, informed Ravi that the price of the car was 10 lakh rupees, not 12, it's 12 lakh rupees, not 10 lakh rupees, printing mistake here. Ravi inspected the car and agreed to purchase it, believing the price of the car as 12 lakh rupees. Actually, the price of the car that is set by the broker is how much here? 12 lakh rupees. So see, again second point. However, Vikas informed Ravi that the price of the car was 12 lakhs. Ravi inspected the car and agreed to purchase it, believing the price of the car as 10 lakh rupees. Means buyer wanted to buy for 10 lakh rupees. Thus, Ravi and Rakesh were not agreeing to the same price. Of course, they are not agreeing upon the same thing and in the same sense, they don't have the consent. Since there was no meeting of minds regarding concession, means no consensus addendum, there was absence of consensus addendum. Therefore, a legally enforceable contract between Rakesh and Ravi, seller and buyer, was not properly concluded. Further, Ravi cannot compel to pay 12 lakh rupees because he never consented to that amount. Of course, buyer cannot be forced to pay this 12 lakh rupees because he did not give consent to buy the car for 12 lakh rupees. Because he acted beyond his authority. Broker, क्योंकि sir, broker are supposed to follow the instruction given here. He was given instruction of how much here? 12 lakh rupees. But this idiot was selling for how much here? 10 lakh rupees. So Vikas acted beyond his authority as broker and may be held liable for the negligence or misrepresentation towards the Rakesh here. So conclusion. Achha, see, in question they ask the 3 points. So we'll give the conclusion in this 3 points only. So see here. Conclusion: no valid and enforceable contract exists between Rakesh and Ravi due to absence of considered. Of course, there is no any valid contract between them. Next, Ravi cannot be compelled to pay 12 lakh rupees since he agreed to purchase the car for 10 lakh rupees only. Next, Rakesh may take legal action against whom? Vikas. So seller can take the valid action against whom? Broker, for acting beyond his authority and causing the loss through misrepresentation or negligence. Because see, third question they ask is, what if the broker never said anything about the price to the Ravi? So of course, sir, here because of his misrepresentation, या फिर mistake, या फिर what it may be, sir, because of broker now Rakesh is incurring some loss, he is incurring some damages here, so he can recover the same from whom? From the broker. So this was about the first question. Now we'll go to the second question. See, question number 1, B part. So we are going to discuss about the B part. Even this was also there for 7 marks, and of course see, 7 marks question means they'll give lengthy case study. You have to clarify each and every point here and always try to give to the examiner a crystal clear answer here. So see, Hithard Foundation was incorporated under section 8 company. It means there is one foundation called Hithard which was incorporated as section 8 company, that we know, with the object to promote a healthier lifestyle of the human being while caring for the planet. So of course, what is the main objective? Healthy lifestyle. Hithard was one among the founders. So one person called Mr. Hithard, he was the founder member of the company, and this company was started in his name only, called Hithard Foundation. Mission of the company was to inspire healthier living by providing pure, organic and sustainability sourced product that nurture both people and the planet. So of course, sir, this was the mission of the company. Next, Hithard Foundation was running successfully in terms of its objectives. So of course, they are carrying their objectives here. Being well aware of the success of the Hithard Foundation, Ram and Son, this one is important, a partnership firm. So firm name is Ram and Sons, in which Hithard fathers Ram was having 80% of stake. Nothing but there was one firm called Ram and Sam. In that, okay, Hitard's father, whose name is Ram, he was having 80% of ownership in that firm. Invested 25% in the equity of the Hitard Foundation. It means, sir, this partnership firm, they bought 25% shares. Ram and Co, they bought 25% of shares in this Section 8 company. Got it? Next, few days later, Mr. Ram started interfering in the business of the Hitard Foundation. So this person, okay, the main person of this firm, or you can say this partnership firm, started interfering with the business of this Section 8 company by supplying the poor quality raw material, which defeated the main purpose of the Hitard Foundation of providing pure and organic product to nurture the people and the planet here. Now let us see the next one. Besides, apart from this, Ram and Son pressured the director, means they have pressurized the director of the company and Hitard Foundation by pressure was forced to declare dividend of 10%. It means, sir, nothing but this partnership firm, they were pressurizing the director and the Section 8 company to pay a dividend of how much here? 10%. And we have seen that Section 8 company in no circumstances can give a dividend here. Ram and Son withdraw its share of dividend, whereas the other shareholder did not withdraw. So see, they said that if you are not going to pay the dividend, then here partnership firm, what they did is they have pressurized to give the dividend of 10%, and they have taken the dividend also. They have taken some amount from the Section 8 company in the form of a dividend, whereas other shareholder did not withdraw their share of dividend on the ground that Hitard Foundation was incorporated for the other purpose. So keep it simple, sir. Partnership firm, they have withdrawn some dividend from the Section 8 company, whereas other investors, they did not withdraw. They were right. And who is wrong here? Partnership firm, Ram and Son. Some farmers who were earlier supplying organic vegetable to the Hitard Foundation and were denied to supply their product after interference of the Ram and Son. So when this partnership firm started interfering, some farmers, they said that we are not going to supply you this organic vegetables. They filed complaint before the central government. Who filed? Farmers, to revoke the license of the Hitard Foundation, stating that now these Section 8 company are not fulfilling their objectives. Central government, after hearing all the stakeholders, gave a notice of revocation of license of Hitard Foundation after issuing a show cause notice of the company. Means central government, they have called to all the parties, they listened to all the parties, and then they have cancelled the license after giving opportunity of being heard. After revocation of license, the central government order for winding up of the health of the Hitard Foundation in public interest. So spelling mistake here we have here. So Hitard. So central government, they said that this Section company should be closed down. Some directors of the Hitard Foundation approached you for your advice in the following. So they are asking you to advise in this following matters: whether Ram and Son can invest 25% in the equity of the Hitard Foundation or not. Answer is yes. Because, sir, who can become a member of this Section company? Anyone can become. It may be individual Section company, individual corporate, or even the partnership firm can also become a member in this Section 8 company. Next, Ram and Son has withdrawn its share of dividend since it has 25% in Hitard Foundation. Whether Hitard Foundation should have denied for the declaration of any dividend. Answer is yes. Because, sir, Section 8 company should not pay any dividend. Next, Hitard Foundation contended that central government cannot give order for winding up. Of course, central government can give any order, that we have seen here. So analyzing the applicable provision of Companies Act, advise the directors. So see, you can read out here, this is the main purpose of starting this company, and this one is important. Section 8 company is prohibited from payment of dividend to its member. In no form you can pay the dividend. Company Act does not prohibit any individual, firm or body corporate from investing in the share capital of Section 8 company, provided the condition of Section 8 are complied with. It means, sir, anyone can become a member. Individual can become member of Section 8 company, firm can become member of Section 8 company. We also call this as the NPO. Got it? Even body corporate can also become a member. So conclusion is, can firm become a member of Section 8 company or not? Answer is yes. Next, under the provision of Companies Act, if a Section 8 company contravenes the requirement of Section 8 or conduct its affairs fraudulently or against to its object, then central government may revoke its license after giving opportunity of being heard. Of course, central government have the power to cancel your license, but before cancelling the license, they'll give opportunity of being heard. After revocation of license, central government may direct for the conversion of this Section 8 company into another company, or for amalgamation with other Section 8 company, or even for winding up. It depends upon the central government here. Then you are writing about the fact and analysis here. The same thing happened here. Got it? And then conclusion. Ram and Son can legally invest 25% in the equity of Hithard Foundation, since investment in a Section 8 company is not prohibited for the partnership firm. Next, Hithard Foundation should have denied declaration of dividend, because payment of dividend by Section 8 company is expressly prohibited. You cannot pay dividend to your member in any form. Got it? Next, the contention of Hithard Foundation that central government can only revoke the license but cannot order for winding up is incorrect. Because central government has power, they can do whatever they want here, but after giving opportunity of being heard in the public interest, they can do whatever they want, legally of course. Okay? The central government has the power to revoke the license and also order winding for the winding up of the company in the public interest. Got it? After following the due process. So this was the second question. Now we are going for third question, which they asked for 6 marks, and as you know that totally you are having 6 questions, out of which you have to answer only 5 questions, and first one is compulsory. So we are just discussing about the first one, which was for 20 marks. 7 plus 7, 14 marks we completed. Now we are going for how many marks? Now 6 marks. ABC and Co, a partnership firm, is going to be dissolved. The partners seek your advice on the following points, referring to the relevant provision of the Indian Partnership Act 1932 in this regard. What are the rights of partner? Rights of partner to have the business wind up after dissolution. Means firm is dissolved, still whether partners are having right to close or wind up the affairs of the firm or not. Answer is yes. Next, continuing authority of partner for the purpose of winding up. It means, let us say before winding up you started one project. Now you have passed a resolution for winding up of the firm, but still okay, you had the project yet to be completed. So even though the firm is dissolved, still you are liable, or you have right, or you have authority to complete that project here. Next, modes of settlement of partnership account. So this is how you have to write down. So first point, they are asking this in the direct question, so you have to write down in the direct form only. So let us say here, rights of partner to have business wound up after the dissolution. So we are going to discuss this one. According to section 46 of the Act, every partner or his representative has the right to have the business of the firm wind up after dissolution, and to have the property of the firm applied in the payment of debt and liabilities of the firm, and the surplus distributed among the partners according to the rate. So every partner, they have the right that once the firm is dissolved, sell all the properties of the firm, pay the liabilities, debts and liabilities, and if there is any surplus, distribute the same among the partners. Next, continuing authority of partners. As per section 47, after dissolution, the authority of partner continues so far as may be necessary to wind up the affairs of the firm and to complete the unfinished transaction which are begun before dissolution. As I said, if you started any project till the dissolution, you did not complete the project. So even though the firm is dissolved, you have to complete that project here. You have that authority and you are held liable. Next, they are asking about the modes of settlement here. So firstly, losses, if you have any loss, shall be paid out of the profit. If the profit is not sufficient, then out of the capital, and if the capital is also not sufficient, then partners individually from their personal property in the profit sharing ratio. Next, sir, whatever the assets the firm is having here, after selling all the assets at the time of dissolution, firstly firm will sell all the assets. What they'll do with that money? Firstly, pay the outside liabilities. Then if any partner have given any advance or any loan, then pay to that partners, and then return back the capital contribution by the partner, and finally if anything left, distribute among the partners in the profit sharing ratio. So this is all about the question number 1. A, B and C part we discussed. Now we'll see the second question in next video.